Having just learned 2 minutes ago that I'm moderating this, I'm going to do the best I can. Good afternoon. I'm Nancy Moravec. I'm one of the co-directors of the Immigrant Rights Clinic. I'm here with Alina Das, the other co-director of the Immigrant Rights Clinic, and Adam Cox, who teaches immigration law here. Obviously, this is a really terrifying time for enormous numbers of people, both here in the United States, people in our community, students who've had a very hard time coming back home from trips abroad, and people who are stranded abroad, people who are right now worrying that they can't travel to family funerals. I mean, what's happened with the executive order is affecting people in a very big way. And that's why we're having this program, both to talk about what the order is, how we're seeing it play out immediately on the ground. So Alina Das was actually at the airport this weekend overnight and can talk a lot about what's been going on. I'll turn to her right away. So Alina, why don't you just start with what we're seeing?
So, first of all, I want to say that I realize that this order affects many of us on a very personal level. So the first thing, just to echo what Nancy said, we want you here, part of the NYU community, to know that we are here for you and we have your backs through this order and the other orders that we've seen already and the orders that we know are to come. And I think that's an important thing to know. And if you are feeling, problems related to the order, whether it's actual legal problems, emotional, mental health, NYU has resources for you, so please come to us if you need that help. We thought we would talk a little bit about what the order actually says. I know many of you have taken a look at it and have read about it, but just to cover it in case folks don't know, the order itself, under the name of Protecting the Nation from Foreign Terrorist Entry into the United States, decides to target the entire U.S. refugee admissions program, suspending it for 120 days. There are some exceptions, and there is a religious minority exception. But for the most part, what we've seen is that refugee admissions have been very difficult for people in transit. There have been issues which I'll talk about, and certainly for people who are outside waiting for the opportunity to come to safety in the U.S. instead will not get that chance, at least for this period. There is an indefinite ban on Syrian refugees. As many of you know, the U.S. accepted about 10,000 Syrians who are fleeing civil war, actually a frankly very low number compared to many other countries, but even that has been suspended. There is a ban on the entry of 7 Muslim-majority countries. These countries are Iraq, Iran, Libya, Somalia, Sudan, Syria, and Yemen. And that is a ban on immigrants and non-immigrants. I'll talk a little bit more about how things are progressing with that. And then there are a number of other things related to screenings and the kinds of interviews that people are subjected to. Essentially, all of these provisions have a result of targeting Muslim communities, our family members, our loved ones, many of whom have very significant ties to this country, yet are being grouped under the label of terrorists. So what does that mean for us? I mean, I think many of you were at the airports this past weekend, answering a call to speak out against these issues, and many of you using your legal skills to help the families who didn't know what to do. On Saturday, we had received an alert that there was an NYU student who was being detained at JFK. And so going there, and talking to that person's loved ones, I personally, and those of you who are there as well, welcome you to share your experiences during the Q&A session. I felt like I wasn't in America anymore. This was not the country that I knew. People were waiting for their elderly parents to arrive, for their husbands and wives, their fiancés, students who were supposed to arrive for school. And it was chaos. No one was able to know what was going on. Initially, when people were detained, and they're detained in these kind of secondary inspection rooms in the back of the airport, they were initially able to make calls on their cell phones, and then they weren't allowed to anymore. So you would get a text every now and then, or maybe someone would convince an officer to let them call a family member or a friend, and then you would just get drips of information. You know, they're telling me that if I don't sign a document withdrawing my request to come into this country, I'm going to get a removal order with a 5-year ban. What should I do? I mean, those were the kinds of questions that were being posed to again, our community members of the NYU community because of this order that was signed on Friday, fairly late in the day, causing complete chaos over the weekend because no one knew what to do or who even to contact to get answers. And so, you know, in the hours that I was at JFK, and I'm very happy to say that that student was released after 25 hours of being held and interrogated, that I saw things that I never thought I would see. A man who had to take his 8-month pregnant wife to the hospital because she was having so much anxiety over the fact that her mother was being detained. Or a soldier, a sergeant in the Army, waiting for his mother who had been detained. Students who were waiting for their friends, because for many international students whose families are back in their home countries, you know, your classmates are your family. And seeing people sleeping in the airport, waiting overnight, wandering through the terminals just to find out where their loved one was held, and no one, lawyers, not being given access to their clients was it was just a horrific thing. And as the moment that the court order came out, there's a court order, I think Adam will say more about it, that was brought, you know, within just a matter of hours. Numerous groups, including the ACLU and Yale Law School and others, filed this lawsuit along with the IRAP group that was part of the group organizing many of the volunteers. They followed a lawsuit on behalf of a very wide class, essentially trying to cover as many people affected by this ban as possible in the Eastern District. And then they raced against time on a Saturday to get an emergency hearing. That stay was announced around 9 o'clock on Saturday. And you know, we were so excited when it came out. People were trying to get a copy of the order so that they could go and show a CBP officer, Customs and Border Protection, and trying to get someone we all felt like this was going to be our moment. People were bursting into tears thinking they're finally going to see their parents or their loved ones. And then it became clear that the people that we were there for had been coerced to signing withdrawals of their admission, and it wasn't clear that the order was going to apply to them. In fact, past midnight, as we were sitting there filing habeas petitions for our clients to try and get the stay to apply to them, one of the individuals was actually put on a plane, and only through a lot of advocacy on multiple levels, they actually had to, and including herself, what she did on the plane, they stopped that plane, turned it around, and took her off, and she was eventually released. But that is what our country is right now. And I know for those of you who have student visas, the idea, you know, even if you're here and thankful that you were here, that you came before this ban took place, now you're wondering if you're even going to be able to go home and see your family. Some people in our community rely on being able to travel to do the studies that they came here to do. So it's a horrific thing, something I never thought I would see. And I think the fact that it is so explicitly based on the many comments that our president has made about Muslims in this country and internationally is really the starting point for these challenges, that this is simply unconstitutional. And so with that, I will hand it over to Adam to talk more about the legal issues.
Thanks, Alina. So I want to speak briefly, in part because you know, we all want to hear from you guys and hear the questions you have about what's going on the ground and what the legal strategy is going to look like going forward. So I'll just say a few words about the litigation that took place in Brooklyn on Saturday and what the possible legal claims are against the executive order at this point. So as Alina mentioned, there was an emergency stay requested as part of 2 individual habeas petitions that were filed in the Eastern District of New York in the Brooklyn courthouse. Those habeas petitions, filed on behalf of 2 folks who were detained at JFK, also included class allegations, allegations for class-wide relief, seeking relief on behalf of a lot of people who would be affected by the orders. And we know that the stay order itself, while it said very little, on its face had a very broad scope. So that the district court judge in Brooklyn issued a nationwide stay against the removal of any person who was currently detained at an airport anywhere in the country, preventing, if the government complied with the order, preventing their removal from the country. And in the short text of the order, the judge indicated that the stay was required not just because of the terrible harms that would occur to people if they were returned, but also because there was a significant probability that the law violated the Constitution. Okay, so let me say a little bit about that. There are a number of different lawsuits that have already emerged against the executive order. They cover a lot of different bases, so let me just talk about 2. The first just really concerns what Alina has been talking about at the airports, which is the kinds of procedures that the government's been using to implement the orders. So the easiest, from a legal standpoint, part of the litigation strategy right now, I think, is that for many people, particularly people stopped at the airports in the first few days, which included a significant number of green card holders and returning green card holders who had traveled abroad and then returned to the country. It is just black letter American constitutional law that returning green card holders cannot be excluded at an American border without due process. And so the individual decisions of CBP agents at JFK or elsewhere is a clear violation of the Supreme Court precedent. Now, everything is changing quickly, and it may be that the procedures to implement the executive order will change in swift fashion. And obviously, folks care deeply not just about what procedures are used to exclude people, but whether, in fact, they will be excluded. And that raises the question of what kinds of constitutional claims, equality or liberty claims, might be brought against these orders, which, as Alina noted, emerged from a really disturbing political context, which included a lot of open statements of hostility about Muslims in America and around the world. And on that front, I guess all I want to do is try to clarify what I think has been something of a misimpression that at least a lot of popular media accounts about the possibility of religious liberty or religious equality or racial equality claims against this executive order might be. I've read a lot of talk about the tremendous authority that the President of the United States wields when it comes to national security, to foreign policy, and to immigration. And that's all true. The President does have tremendous power to shape American immigration policy. President Obama used that tremendous power in part to announce programs like DACA to provide release from deportation to large numbers of immigrants who had come to the United States as young people. So it is absolutely true that the President wields tremendous power of immigration policy. But as is kind of all too often happens in popular discussions of complex legal issues, a lot of really important legal and constitutional distinctions, I think, have been flattened in discussions about that power and the deference of courts to presidents in the immigration context. And the mistakes, I think, that have been made are twofold. The first is that there's been a assumption in some of the writing I've seen that because these policies affect non-citizens, they're immune from constitutional assault. On the theory, I suppose, that non-citizens in general, or certainly non-citizens outside this country or standing on the threshold of entry to this country, just have no constitutional rights, or at least no constitutional rights they can go to court to assert. And that belief is wrong. It's contradicted by more than a century of Supreme Court precedent, and if true, would leave us in the position where we couldn't explain why it was that just a few short years ago, the Supreme Court held that enemy combatants detained at Guantanamo Bay, non-citizens with no prior connection to the US who were dragged to Guantanamo Bay against their will, those non-citizens were found to have constitutional rights to challenge their own detention. So the notion that a returning green card holder stopped at JFK somehow lacks constitutional rights to challenge the constitutionality of this executive order, I think, is difficult to square with existing doctrine. Okay, so one mistake is, I think it's a mistake to believe that because this order affects non-citizens and non-citizens are not in the country, that somehow immunizes it from judicial assault. The second mistake that I've seen is there seems to be a belief that because American immigration policy has often, over American history, included ugly episodes of discriminatory treatment on the basis of race, religion, ideology, and because in many cases courts have sustained those policies against assault, that means that even if a court today believed that the executive order reflects an invidious intent to discriminate against Muslim immigrants, that even if a court thought that, it would nonetheless sustain the order because of this long set of precedents in which courts have, over time, sustained discriminatory immigration policies in America. And there's a kind of superficial appeal, I think, to that claim, but that claim, too, I think, really misreads the history of American immigration law. So it's true that in 1889, the Supreme Court upheld the Chinese Exclusion Acts, right? Acts of Congress that on their face excluded immigrants from this country on the basis of their race. And in 1952, the Supreme Court upheld the deportation of a former member of the Communist Party against a challenge that violated the First Amendment. And in the mid-1970s, the court upheld sex discrimination in the green card preference system that treated fathers worse than mothers. So all of those things are true. But it's also true that those cases were all decided in constitutional eras where those kinds of discriminatory policies were accepted as a matter of domestic law too. So Che Jianping, the infamous case upholding the Chinese Exclusion Acts, it was decided just 5 years before the court handed down its decision in Plessy against Ferguson, right? A case that gave us the principle of separate but equal and endorsed and ratified Jim Crow segregation in the South that persisted as a formal legally acceptable policy until Brown against Board of Education overturned it in the 1954 decision. And in 1952, when the court upheld against a First Amendment challenge the deportation of former communist members, it was a period in which First Amendment protections were watered down, and it was not unusual for members of the Communist Party to be criminally prosecuted. And in the mid-1970s, when the court upheld sex discrimination in this case Fialo against Bell, we were in the very nascent stages of the court's sex equality jurisprudence, right? Ruth Bader Ginsburg was still losing, I think, the majority of her cases, not winning them. And it was not at all clear that instances of clear discrimination on the basis of sex would always be invalidated. And so I guess the important point that I would like everyone to walk away with is the realization that never has the Supreme Court upheld an American immigration policy that openly discriminates on the basis of race or religion or ideology during a period of American history when such a policy would have been thought to be obviously unconstitutional in domestic contexts. And so I think that should give us some hope that courts would take seriously the allegations about discriminatory animus underlying these policies. And I'll turn it over to you.
Okay, so thanks, Adam. I want to just add a little bit more about where we are right now. The people who were being held at JFK Airport, have now, and who weren't returned, have now been released. But this policy remains very, very much in effect and affecting thousands and thousands of people. And the reason is that what the administration has done is it has scared the airlines into not allowing people to board airplanes so that they aren't able to come here and present themselves in airports and then get the benefit of the orders that have been issued by the courts. So there are heartbreaking stories going around on listservs about people who, are caught in transit. You've probably seen some of these in the news as well. People who have all kinds of reasons based on valid visas to be traveling to the United States, including people who live here and who were just out of the country and sort of are now trying to get back, that people are just not allowed on the planes in the first place in order to come and present their claims in front of the customs inspectors, the immigration inspectors at the airport. So that's what's happening. And if you think about what that means in terms of basic concepts of the rule of law, it is so disturbing. You have people who stood in line. You have people who paid their fees. You have people who paid lawyers, people who went through 2 interviews, who were approved for a variety of visas, who, you see stories on the news of what somebody gets approved for a visa, they quit their job, they give up their apartment, they pack their bags, they go to an airport, they're ready to board a flight on something that they have been given every reason to think is a valid visa, which, yes, you are inspected on arrival, but, if there's no problem with your visa, that is a fairly pro forma process. So you have people like that, people like the people Alina was describing, who are waiting for relatives to come and visit. I mean, you have people who are waiting to come and sort of see their first grandchild, or waiting to come because they're scheduled for surgery. I mean, these are all real stories that I'm not making them up. These are all very real stories that are happening. And so the efforts to say, oh, well, there was just a few hiccups in rolling out this policy, it's just a little inconvenience for over 100 people or something, not only are those, like the inconvenience ideas, sort of clearly not true in talking about what was happening to people, but there is this ongoing effect where people cannot come back to the country who have valid visas in this country and who are waiting who are, I mean, somebody might have gone on vacation. They went on a 1-week vacation. They don't have the resources to be somewhere else for months waiting for this policy to unravel. They have their tickets booked to come back, but then they aren't able to board the plane. Or people who, paid their money to come here. I mean, there are just a lot of reliance interests. And so ordinarily you have the idea that there would be some sort of rule of law in the way the government would disrupt expectations that people reasonably have based on the government structure. We have this huge immigration law with lots of regulations, and people have done everything in accordance with those regulations. People have enrolled in university degree programs. They might be a couple of years through. There are huge reliance interests that people have in terms of being able to come back and resume their studies, their work, have their income to pay for their apartments, just everything about people's lives that have been, for the people affected by this, people who are not here right now, it's just a phenomenal disruption. And ordinarily, when Congress tries to do something like that, when Congress totally disrupts people's expectations, there's a doctrine that's very well established where the courts are extremely reluctant to read Congress as having meant to do that. That's been applied. So when Congress, for example, retroactively made people's membership in the Communist Party, 20 years earlier, grounds for deportation, the Supreme Court said, well, we'll assume Congress didn't really mean to do that. And then, unfortunately, in 1940, they said that's exactly what we mean to do. And that was ultimately upheld in the cases that Adam's talking about. But there was first this check, did Congress really mean to do this? And when an agency passes tries to promulgate a regulation that applies retroactively, there is Supreme Court case law that says that is just not something that's, we do not assume that Congress meant to give this agency the power to disrupt people's reasonable expectations, even when we're talking about expectations much less serious than the ones that are involved in people's live studies and so on that have been completely disrupted by this executive order. So I think it's an interesting question. What do you do when it's an executive order coming from a provision in the law that, could be read as sort of saying, well, the president can do anything he wants, can't really mean that, Does it mean he can do anything he wants if he, well, I won't go through all the possibilities, but I mean, that's the question. Does it? And I think that's also going to be a question for the courts. I mean, is this power, especially given what we know about the reasons that there's so many statements that show an intentionally discriminatory purpose based on religion, or, that the reason is I'm fulfilling a campaign promise, everybody should have known for a year that this was something I was going to do. Is that the kind of power that allows the president to unilaterally dismantle expectations that people have from proper visas, trips pursuant to those proper visas? I think that will be an interesting question for the courts as well, because that's what's hitting people immediately. And you just have to ask if you, had sort of arranged that you were going to go study somewhere in another country, and you were halfway through your program, and they suddenly said, well, you know what, you're not allowed to be here anymore. Just how wrong that would be, especially when there's no reason that is possibly really justifying this. I mean, the reason of something that happened 16 years ago, which the 9/11 events, which by the way did not just affect citizens, as the president says in his order, but affected many, many non-citizens who lost their lives in the World Trade Center. That cannot be the justification for this kind of sort of unlimited presidential power. So that's just another thought. So anybody else want to? Yeah. 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 So if people want to come up to the microphones and ask questions, we want this to be as open a discussion as. Yeah, please go ahead.
Thank you for speaking to us today. So in regards specifically to the inclusion of green card holders in the executive order, there seems to be some very cloudy, confused messaging coming regarding that. DHS and Reince Priebus indicating this doesn't apply to green card holders. The White House issuing a statement saying it does, clearly based on the text of the executive order, it does. Probably a key figure here is Steve Bannon, who's advocated for this kind of stuff for years and is getting more powerful with his promotion to the National Security Council. How do you read into this? Is the green card inclusion a sloppy oversight? Is it meant to be a distraction from the other parts of the ban? Is it more sinister? What's it tell us?
So you're right that the messaging has been confusing, and so what I am about to say I'm not 100% confident of, but my understanding of the administration's current position about how the order applies to green card holders is that green card holders are covered by the text of the order. So in that way, they are included within the immigrants who are affected by the order. But the order includes a provision that permits in limited instances for the CBP agents essentially to exercise their discretion to let into the country a person who otherwise is subject to the ban. And my understanding is that the administration has taken the position that it is instructing the bureaucracy to use its discretion to let into the country under this exception, green card holders who are otherwise covered by the ban. Now, that's important because it means that this order does apply to green card holders, and if they are permitted to enter the country, they're being permitted to enter the country not because they're being treated like other green card holders from other nations, but because they're being given as an act of grace a discretionary permission to enter. So on that understanding, my sense is that there's still a sense in which green card holders from the 7 listed countries are being treated differently and worse than green card holders from other countries around the world.
Yeah, and I think we're seeing that in terms of the inspections that are still taking place, that people are, and these inspections are very invasive. So in the airport, many people were handcuffed, behind these closed doors. People's cell phones were taken. They were asked for their passcodes. They went on Facebook and social media. It's a level of scrutiny that I think is very offensive to many of us. And so green card holders are still subject to that kind of inspection. It may get better over time, but they still are, but they are coming in. But to me, to answer your broader point, again, we're all just making assumptions here. But for the Secretary to issue this statement so shortly after the ban was announced or signed, I think it just adds credence to a theory that this order was very sloppily put together and that people who actually know how the immigration system works and how this would be affecting various groups of people were not consulted as part of the process. Again, that's an assumption. But when you see the way people were reacting to it who do this every day, even the CBP officers, I'm sure there are many CBP officers who are very supportive of this ban, but we got the clear sense that there were many CBP officers who were not and thought it was outrageous that they were being asked to do what they were being asked to do. And again, when you see someone being rolled out of secondary after hours and hours of detention in a wheelchair, it makes you wonder how it is that people didn't think about what this would look like on the ground. And so I'm of the theorists who think that it was very sloppily put together. And now that they're seeing the reaction and the outrage on the streets, which I think was incredibly important, they're realizing that they need to roll back a little bit, but it's still incredibly problematic.
I mean, just one more thing on green card holders is that the airlines are allowing green card holders to get on flights and to book tickets. So they are able to get to this process where they will then be looked at, which is different from other people, at least as of now. So next question.
Yeah, so for certain parts of the order, I understand that it applies indefinitely to Syrian refugees, but for others, there's certain time limits, the 90-day, the 120-day. So I guess my question is, what is the likelihood of those time limits being extended, and whether or not that would affect any challenges of the order?
So there's this effort to pretend that this is temporary so that people are just being, as I said, inconvenienced. But if the way the order is structured, the temporary suspension is during that time, these 7 countries are supposed to provide information and then there's supposed to be a report about the response from those countries. And then after that, there will be an evaluation about whether to continue the suspension. And I have to imagine that the governments of these 7 countries might not feel, who knows how interested people will be in cooperating with a government that has treated their nationals so poorly. So I think it's sort of hard to say what's actually going to be happening. I mean, the other thing I would just say is the order allows other countries to get at it. So, it sort of keeps this threat hanging over everybody, both time-wise and in terms of other countries.
So I imagine that there are 3 classes of people here. There are the visa holders who get detained, there are the visa holders who don't enter, and then the people who don't have visas are just denied based on their nationality. How do the constitutional arguments differ between the 3, if at all?
You want to take that?
So that's, I mean, it's a great question and a tough one. I don't think we can give a complete answer right now. So I guess I'll just say two things. The one important point is that the kinds of constitutional claims at stake might matter. So it's not like we have a constitutional system where non-citizens are situated on rungs of a ladder that they climb up and acquire additional, protections at each stage. With respect to some constitutional rights, most expressions by the Supreme Court suggest that every person in the world might be protected. So even in an infamous 1952 decision which upheld the indefinite detention of a man confined at Ellis Island, I think, stopped on the basis of secret evidence when he was returning to the country. Even the majority, which sustained the detention, said, well, but of course it wouldn't be permissible to torture the person or to set him adrift in a lifeboat, irrespective of his status. And so, yet with respect to, say, due process rights, it is clear in Supreme Court precedent that both the legal status of a non-citizen, the kinds of ties that they've developed in the United States by virtue of their residence here over time, as well as their position, either in the territory or outside of the territory, like all three of those factors might influence the force of the due process objections that a non-citizen could bring in this context. And so that does mean, we need to know what the constitutional challenges are. It also means that, in many contexts, the returning green card holders have the clearest, easiest doctrinal footing because there's so much case law providing evidence that green card holders have robust due process protections in these contexts, and evidence that because they're treated as though they've never left, really, like a green card holder who travels abroad is treated as though they've never departed, there's really no question that they could bring religious liberty or equality claims just like any person living in the country could. And it's been true since Yickwo against Hopkins, another famous late 19th century constitutional law case, that non-citizens, irrespective of their status, living in this country, have the same rights to racial equality and religious liberty as the rest of us. So in that respect, we do not have a constitution that's structured to provide a kind of privileged position to citizens over non-citizens with respect to those kinds of core protections in the country.
Yeah.
I was going to ask a very similar question. So I'm interested in what constitutional claims you think could be brought on behalf of non-green card holders. And I guess piggybacking off of that question is, did any of the court orders that were already issued differentiate between green card holders and non-green card holders, or immigrants versus non-immigrants? Or if not, what kind of claims could be brought in the future?
Yeah, so I believe that one of the court orders had to do with green card holders. I'm not totally sure of it. The court orders are slightly different. Some expressly talk about detention, some don't. Some talk about access to counsel, and others don't. So there are some variations. I will say that there's a strong statutory argument that applies to people who are not returning green card holders, but are people who've been processed to come in as immigrants as green card holders. That the statute also has a strong non-discrimination provision. So you have this both statutory argument and constitutional argument. But as Adam was saying, there are constitutional arguments that run throughout people of different status.
I would just add that obviously with the refugee part of the ban, that there have been significant litigation on that specific area, because it also, all of these cases invoke a lot of international law protections, but particularly in the refugee context. But this is to say that I think there's a baseline constitutional statutory problem with every aspect of the ban, and it's just that for certain populations there may be additional arguments. So I think that's the hope, that as a community, as a legal community,
people are going in there very quickly, throwing out these theories to show why this is unconstitutional. But the idea is not to say that one group should be preferenced over the other, rather to say that all groups need to be protected, and that we're going to use the tools that you can use on top of that may be particular to different groups because of the way that the immigration law is structured.
And if I can just add one thing about uncertainty in the law and the role of the courts in all of this. It's not just the pending habeas cases that are relevant. So there are actually 2 cases pending right now before the Supreme Court, one which was argued in November and one which is at the cert stage, both of which concern the constitutional rights of non-citizens in different kinds of statuses and contexts. One of those cases involves the prolonged detention of immigrants, some of them arriving seeking refugee status, some of them green card holders. The other one concerns whether arriving immigrants seeking refugee protection have even habeas rights in the courts. And so those cases, which are before the court right now, are very important. And in the one that was argued in November, it was argued on largely statutory constitutional avoidance grounds, and after the argument, the Supreme Court requested supplemental briefing from both the government and the immigrants on the constitutional questions, on the questions of how the Constitution might constrain the government's power to detain non-citizens in these different classes. And so that constitutional issue is actually squarely before the Supreme Court this term. And I'm sure the Supreme Court is well aware of the way in which the manner in which it decides that case could have big implications for these new policies.
Yeah.
All right, my question goes back to a point that I think was slightly discussed, which is how some of the court orders are slightly different. I think the Massachusetts order talks about detention, and the New York has just stay on removal. And just a very basic question, I don't understand the difference between detention and habeas and how those questions arise just in general, like how it would be argued. And then the other question I want to ask is right in the face of the executive order is this exception for a particular minority religion, as well as I think Professor Cox talked about invidious intent. And I was just wondering if there is an establishment clause sort of argument, how that would proceed and what sort of evidence would need to be brought forth.
So maybe I'll talk about the habeas piece, and you can talk about the religious exceptions. So, one of the crux of habeas and the power of the courts has to do with custody. And in the most, kind of traditional, long-standing sense of that term, executive detention is where the heart of habeas jurisdiction lies. It's a way to get into court and to have courts question the executive's detention authority. So I think for that reason, having people come in, challenging challenging this policy by virtue of the fact that people are detained here was the clearest way for some of these court orders to come in. But the reasons why certain orders were just preventing removal versus also trying to challenge detention and seeking release probably has to do mostly with what was crafted in the complaint and what people were able to get courts to do on this emergency basis. One of the things that was true of the lawsuit here in the Eastern District of New York is that people were able to get the named plaintiffs out, that thanks to a lot of work on behalf by their lawyers as well as congressional officials. And then there was a sense that people were still going to be removed rapidly. And so that accounts for some of the differences in terms of what was covered. But I think there is a very strong sense that now is the time to double down on habeas, not only having this kind of limited construction of what it means for custody, but to rely on the cases that have said, we should be able to use this writ to protect people who are not even in that formal custody situation, but are essentially locked out of the United States, but have ties here. So this is a time for a lot of creative litigation. And as somebody who has filed a few of these habeas petitions now in just the last few days, we haven't had time to really think through all of the issues, but the important thing was that to be able to go in and see what courts can do. And so, I was incredibly amazed and impressed by
all of these individuals across the country, organizations that put together this litigation, and now they're all trying to sort out how to make it as extensive as possible going forward.
I'll defer mostly to Adam Samaha, the other Adam who teaches here on the Establishment Clause claims. But loosely speaking, I think it is important to distinguish between two kinds of claims. So one kind of a claim is a claim that under the Establishment Clause, government policies that are deliberately designed to disadvantage a particular religion are unconstitutional for the same kinds of reasons that government policies designed to single out a racial minority for disadvantageous treatment are unconstitutional. So the doctrine looks roughly the same. But there are other kinds of Establishment Clause doctrines that don't even require the finding of that kind of animosity or invidious intent. And there's a kind of denominational neutrality principle that courts have applied in the Establishment Clause context. And many have argued that this minority religious exception in the refugee language of the executive order, just on its face, violates that principle of denominational neutrality, because in any particular sending country, any country from which people might be fleeing persecution, the order makes clear that members of one particular religious faith, the minority religious faith, are preferred in the refugee process to members of the majority religious faith. And so many scholars of the First Amendment have argued that that is a clear violation of this principle of denominational neutrality laid out by the court, actually in a series of opinions, many of them authored by Justice Kennedy.
Thank you.
So, yeah.
Thank you so much for this. It's been really incredible. So I have two questions. The first is about a comment that was made, I believe, by Professor Morowitz about the government threatening airlines in terms of allowing visa holders, valid visa holders onto planes. Do you see a basis at all for bringing TRO claims against those airlines on the basis of the existing TROs at all? I mean, this might be theoretical, but maybe not. And then the other question is about the detention authority. So as has been mentioned, some of the orders explicitly say you can't detain, others don't address it. Is there, for those that don't address it, is there a basis, assuming you cannot deport, is there a continuing basis under either the executive order or any other regulations governing CBP to detain visa holders at the border point? And if so, is there a limit on that detention at all?
Okay, so maybe I'll just address the airline question, and Alina, maybe you want to talk about the detention question. The problem with the airlines is that airlines are fined if they bring somebody to the United States who cannot come into the United States, and then they have to pay to take them back, and they suffer fines. There's also some discussion about, air carriers in the language of the statute talking about suspension. So there are these provisions in the law that sort of make the airlines very reluctant to bring somebody who's going to be turned around. So the airlines were relatively quick to start issuing, instructions to their employees to not book tickets, to not let people get on the plane, to not let people transfer, and so on. It's a question whether one could sue the airlines and what the basis is. I don't know of those kinds of lawsuits existing, but I do know of people questioning airlines and whether it's appropriate in a situation like this where there are orders that require people to be allowed to be processed when they arrive, whether it's really proper for the airlines to not let somebody board in the first place. And there's also a bit of a movement to sort of get airlines to step up and do the right thing on this. So those are the questions. But this approach that the government has of sort of trying to push the border back is one we've seen before. I mean, we've actually worked on it in the clinic for starting in a case maybe 10 years ago or something, where our client won a case in court, and then we couldn't get the client back. And the reason we couldn't get the client back was because the client couldn't board a plane, and we couldn't get anybody in the government to issue a document that would let our client board a plane. So we've dealt with that issue before, and people have tried to sort of go into court and say, as Alina was suggesting before, that the border gets pushed back. If you're constructively sort of preventing somebody from getting to the border in that way through government sort of action of these penalties to airplanes, to the airline companies, that then you can bring a habeas. If not a habeas, maybe you can bring some other action. But on the question of detention and how long,
well, I would say, just to add to Nancy's point, that among those who are leading the fight to essentially call airlines out for those policies are NYU students here, the law school. So kudos for you for doing that. I think it's incredibly important, and just having to help someone who wasn't able to board a plane, who literally had to walk across the bridge from Canada to Buffalo, New York last night. It just shows how extreme things have been, and how the system makes absolutely no sense. And how the airlines are really not stepping up and are kind of capitulating to this ban. But the issue of detention, so you basically hit the nail on the head, right? If you can't remove someone, right, and that's what the order at least says here in the nationwide order out of New York, then how is it that you can detain them? So when detention has to have some sort of purpose related to immigration and the immigration context, what the immigration system is doing. Now, there is long-standing statutory, regulatory, legal precedent that says it is okay to subject someone to a screening when they're entering. And then if that person is placed into either removal proceedings, formal or informal, there are other regulations or statutes that might apply. So the limits, they may depend on the statute. Now, the case that Adam mentioned has to do with the 6-month limit. So the idea that you're being detained without due process in many cases, no right to a bond hearing, the way in a criminal context you would get the right to bail. In immigration context, there are several different categories of immigration detention where you're not given the right to a bond hearing. How long can that last? And that's what the Supreme Court is going to decide. Both the case was litigated as a statutory issue. They basically turned it into a constitutional issue, which is a very interesting twist. And so that's why I think all eyes are going to be on the Supreme Court. But then that doesn't answer the question here. So what we're seeing here is inspections that are taking, more than like an hour or two, but, 7, 8, 10, 20, 25, 26 hours. Does that cross the line from being an inspection to something else? And where is the authority for them to do that, these kinds of, the quote-unquote extreme vetting? So people are definitely looking into challenging that, and obviously it was part of the Boston case focusing on detention. But I think we'll have to look out for it, because what was happening at the airports, it's actually been happening for a long time, targeting Muslims of all sorts of places who are coming to the U.S., but on a smaller scale, and now we're seeing a very public support for it, and hopefully that will mean a lot of public action against it to try and challenge the basis for holding someone under these conditions.
Yeah, I'd just add, with these cases in the Supreme Court, and the Supreme Court this term has 8 different cases that bear on immigration, law enforcement, citizenship, suits against the government for actions taken that are, sort of for torts that are related to immigration agents and so on. So it has those 8 cases, and it will be very interesting to see how the court approaches this, because in all of these cases, the government argues for immensely broad powers. For example, the government is arguing that they should be allowed to criminally prosecute somebody for procuring naturalization improperly based on a misstatement that doesn't have to be material. Their argument is that it doesn't have to be material. Well, in these kinds of cases, when the court is deciding these questions, there's always in the back I would imagine in the back of their mind, some assumption about how these different branches would actually exercise these powers. So that, as to detention, as to other things, do we presume some reasonableness on the part of the authorities, on the part of the prosecutors or whatever? And one of the things that I think this past weekend shows is that this government will try to take any law to the maximum extent possible. And so, if the court does not hold in prolonged detention, does that really mean no limits whatsoever, which is what the government is in a sense asking for? Yeah.
So I've heard people talking about something, a credible fear assessment or something like that, and with relation to the requirements of the U.S. statutory refugee law. And so I guess I'm wondering what exactly does the U.S. refugee statute that internalizes the International Refugee Convention require in terms of process, and has Customs and Border Patrol clearly violated this U.S. statute?
So one of the laws that was put into effect back in 1996, which allows for this expedited removal of people who arrive at the border, this law generally gives enormous power to border protection officers, because if they think somebody comes in and they shouldn't be in the country, they can order them removed, and then for 5 years they're barred from coming back. Well, there's an exception in the statute that says if the person presents a credible fear of persecution, then you can't just put them back. You can't order them removed right away. You have to give the person an opportunity to show their credible fear, and then after that, go through the process of evaluating their claim for asylum. One of the things that was tricky, obviously there were people who were coming this past weekend who did have fear claims that were, for example, people who were already found to have fear through refugee processing, or there could be other people who were coming for a variety of reasons, but who would have had real fear in being removed. And I don't know to what extent those people were being denied credible fear hearings. Others might know about that. But I think one of the things to really understand about this law is that when you give as Customs and Border Protection officer, the power to say to somebody, we're going to remove you, and for 5 years you will be barred from coming back into this country, that's enormous leverage that's being given at the lowest levels of officials for the agency. And what was happening at the airports, which we know was happening because there were many reported instances of this, including the client that was described before, the NYU student, is that the border protection officers were pressuring people to withdraw their request for admission because otherwise they would get this order that would bar them from coming back for 5 years. So, you have a student who has every right to come back and continue studies being told, well, you will get that bar. But there is that exception where somebody has fear. But obviously, many people with completely legitimate reasons to visit the United States, to see family, to return from trips and so on, are not fearing, not expressing fear, and the credible fear process doesn't offer them anything. Yes?
Thank you. Okay. This is sort of a strategy/fact check question, and you might not have an answer to it. So the media on Saturday and Sunday reported some instances of CBP officials refusing to abide by, especially the Massachusetts order, as I understand it. And my question is to what extent that seems to be isolated, and what the strategy is if that becomes a wider spread,
Of failing to abide by the court order? Is that?
Yeah, I mean, a lot of the past discussion have been constitutional doctrine, right? So that's still, there's a compliance aspect to that.
Yeah, no, so there are numerous reports of people in various border entry points failing to comply with the order. And so that's something that many people are doing right now, is trying to collect that information so that it can be presented to the court. I believe there was a case in Los Angeles where they ordered the government to bring someone back when they were deported based on the order. So trying to find out people who've been in those circumstances so that we can try to bring them back. And as I mentioned earlier, we experienced that ourselves where, the order came down. We were waiting for hours for our clients to be processed and released. And during the midst of that, one of the friend of a different student gets a phone call from her saying, "I'm on a plane right now." This is hours after the order came out, and when CBP had all of the notices. And as I said before, that through a lot of intervention, that plane was stopped and that the person was taken off the plane and then re-detained and eventually released. But it raises a lot of questions about who made that decision, why did they make that decision. There's no way they didn't know about the order because that was the big event of the day. So then what was motivating them? And as we see those cases, I think it'll be very important to make sure that the courts are enforcing the order through these kinds of orders to the government to bring people back. And then certainly I care personally a lot about the people who were sent back before these stays started being issued. And we already have heard reports about lives being ruined because of this. And so I think this is where we're going to have to rely on our communities to try and help identify people and connect them. You are all incredible resources as law students and people in the legal community. So there's a lot we can do to help people as we identify theories for people who are removed before the order was in place.
Thank you.
Yes.
That's
our
actually a
last
perfect
question?
segue to my question, which is if you have advice of ways we can help either law students or people who are trained as lawyers but don't know a lot about immigration.
So there's still, I think it's now a website. It's actually pretty incredible how much mobilization happened at the airport and the organizations that really started it from the beginning, which is wonderful. I believe the website is No Ban JFK. And you can go there and find out ways of volunteering. At this point, I think almost every airport has its own either website or social media account where you can basically, and they'll have email addresses where you can find out in your communities like how you're able to help. People are still being detained. Under this order, there's still being these lengthy invasive inspection processes. So of course, we know that in JFK, there are a lot of people on the ground, so you have to check in to see if they still need volunteers, interpreters, even people who don't have legal backgrounds. Obviously, everyone has skills to bring. I think when we were there, it was a mixture of people who had like media experience to make sure the stories were getting out to people brought by food and other things for the families and for the volunteers. It was a pretty incredible effort. I think the other thing is to really organize. On Saturday night, when we were getting all of this bad or conflicting news, when our clients were still detained even after the stay, the fact that it was 1:30 in the morning and there were people chanting and protesting outside was something that was really valuable to the families that were there, to know that this didn't represent America, and that was actually, that the protest is really what America is. So I think that that's incredibly important, the organizing, the spontaneous organizing, like the idea of NYU Law students organizing to basically pressure airlines to be putting people back on planes. There are a lot of creative ideas, and so I think those are ways that people can get involved. And of course, supporting the organizations financially that need the help. I think as this ban goes on, it will not just be the big organizations, but really it's going to be the community organizations that are supporting families who are directly affected, who are separated by the ban, and really thinking about how to support those smaller groups that are really trying to organize their own communities to fight against this, and thinking about how we in the legal community, not only by doing our amazing legal work, and there's about 50 million lawsuits that people are trying to figure out how to bring, so you can all contribute your legal minds, but also in other ways directly to the community, I think will be incredibly important.
I would just add, this is just it's not actually the first executive order having to do with immigration. It's the third. There are more in the works that have been posted on Vox. We don't know whether they're actually going to be signed. But these orders are, every one very, very scary in one way or another. And so we just sort of, I was saying earlier, the definition of terrorism is when people are disoriented because there are things they can't go about their ordinary lives because things happen that are unexpected and totally disorienting because they don't follow any convention that you would ordinarily follow. And I feel that that there is a way that those of us doing this advocacy are facing a form of sort of terroristic assault on the values of the country and on the things we're doing and on the communities that we serve. And this is just one of the explosions, and there are going to be others. And the mobilization against it and people sort of focusing on their values and the country's values, I think, is going to continue to be incredibly important. So thank you, everybody.